Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we are going to circle back now onto forced reset triggers. As we know, that is just yet another ATF rule that has been absolutely decimated by courts that are willing to uphold constitutional standards. Now, along the way, the Department of Justice has been begging for somebody to bail them out, just begging for somebody to put a stop to the bleeding. They have tried once again, and it has gone just about the way everything else has, which is a complete and unadulterated failure. The dates have changed a little bit about how they're going to have to perform. So for some of you out there, you need to circle something on your calendar. So today, let's spend a few minutes and let's talk about, so when are you getting your forced reset trigger back? Okay, and today's video is brought to us by, yeah, right. Okay, so hey, listen, before we get going too far down the road we're going down, I'm proud to announce that this video is being brought to you by, but don't tell anybody, Taylor Freelance. Now, we would love to show you all the cool things that Taylor Freelance is making right here in the United States of America. That's right, because they're based right there in Bellingham, Washington. But here's the deal. If I start showing you all the cool stuff they're making, well, then Google and YouTube, they're going to kind of crap their pants. Let me just say it this way, though. They don't make firearms, got that, Google? But they will make your firearms a lot better. So whether you're looking for base plates, brass back straps, or any other component to make your firearm better fit for your use, well, then you need to go visit my good friends at Taylor Freelance. Now, normally I'd just go ahead and run the little link right down below, but yeah, you see, Google get a little pissed about that too. So instead, that's a link to our partner page right there. You can go there and then you can find the good folks at Taylor Freelance and check out all the cool stuff that they're making, because you know it's cool if YouTube doesn't want it here. Okay. The case that we are talking about today is National Association for Gun Rights v. Garland. It is a very successful challenge to ATF's unconstitutional and unlawful rulemaking order as it relates to forced reset triggers. It is a case that is obviously brought to us by our good friends at the National Association for Gun Rights, which means we will put a link down below so that all of you can show them some love. This case is filed in the United States District Court for the Northern District of Texas. It has a very, very long history, but it is important for you to understand the history so you understand exactly what happened. So, on August 30th, of 2023, the court granted a temporary restraining order finding that the rule is likely unlawful, and that temporary restraining order actually still remains in place up until what we're about to talk about today. On August 2nd, there's an evidentiary hearing on whether or not the temporary restraining order should be extended for the life of the case, or what we like to call a preliminary injunction. On October 7th, the court granted that preliminary injunction. Now, let us remember that when a court is granting both a temporary injunction and then a preliminary injunction, they are finding that there is irreparable harm and that the plaintiffs are likely to prevail. The historical background of this case continues as follows. Within 30 days after the court granting the preliminary injunction, the Department of Justice filed an appeal with the Fifth Circuit, which is akin to throwing rocks at the moon. They also asked for expedited briefing down in the circuit court. The trial court then denies any motion to stay pending outcome of the Fifth Circuit. And the very next day, the Fifth Circuit says, no, we're not jumping in here. We think the trial court has gotten it right. Now, they put the case on a timeout for a while, waiting for Cargill v. Garland to come down to see if there is some instructive language in there. And then, of course, once Cargill v. Garland comes down on July 23rd, the court grants the plaintiff's summary judgment motion, which is huge because the court basically says, we don't think there's any issue as to the facts. We don't think there's any issues as to the law, and the National Association for Gun Rights is entitled to a judgment as a matter of law. That is a huge, huge ruling, especially on a summary judgment motion. So here we are now, and they are asking for a stay pending appeal to the Fifth Circuit. And again, if ever there is a court that's likely going to wipe its rear end with an ATF rulemaking order, it probably is the Fifth Circuit Court of Appeals. Now, knowing that the answer has been no all along, what do you suppose the answer was this time? That's right, it was a big fat no. Now remember, in order to get any type of injunctive relief, the Department of Justice would have had to prove that they're going to suffer irreparable harm and they were likely to prevail on the merits. Now, that second part is really, really difficult considering the fact that at no stage of the proceeding by any court that's ever reviewed anything that's ever been argued here has anyone sided with the Department of Justice. But hey, let's give them an A for effort. The court also, in this order denying the stay, pointed out a stay is not a matter of right, even if irreparable injury might otherwise result, but it is instead an exercise of judicial discretion, and the propriety of its issue is dependent upon the circumstances of a particular case. And that's right. A stay such as this or any injunctive relief is not a matter of right, unless, of course, you are the state of California in the Ninth Circuit. Now, after Cargill came out, obviously, Department of Justice is like, oh, well, see, this totally proves our point. And of course, both the plaintiffs and the trial court here is like, what exactly are you talking about? What Cargill case did you read? And they actually went on to state, the court must first consider whether defendants have made a strong showing that they are likely to succeed on the merits. They have not. Both versions of Cargill support the conclusion that the ATF's classification decision cannot stand. Indeed, the record in this case is clear. FRTs do not fire multiple rounds with a single function of the trigger and thus do not qualify as machine guns. And then, of course, the Department of Justice relies on the old standby, the but argument, which is, but, if you don't allow us to ban these things, these might end up in the hands of evil people. But as the court points out, next, defendants reassert the claim that the court's ruling will result in the acquisition of FRTs by prohibited persons. As explained before, this concern exists with any firearm, not just FRTs. The court is still not persuaded that the defendant can punish law-abiding citizens, the innocent, because there are criminals who may commit crimes. The court cannot grant the extraordinary remedy of a stay pending appeal based on what a prohibited person might do. And that would be essentially akin to banning all cars because we're concerned that some drunk drivers might get behind the wheel of some of them and hurt some people. Okay, now here's what the court is gonna and not gonna do, okay? Remember that they have found in favor of NAGR on summary judgment. They are not gonna stay that judgment pending appeal. Department of Justice is more than welcome to appeal to the Fifth Circuit. Good luck with that. But this ruling and the finding that the NAGR has prevailed and that this rulemaking order is unlawful remains in effect. However, the compliance, because you got to remember that the ATF was also ordered to send letters to all the people that they already sent nasty letters to and kind of say, well, I guess on hindsight, FRT standing alone do not constitute machine guns. And then for some of you, you are actually entitled to get your surrendered FRTs back. The order of the court specifically reads, pursuant to the inherent power of federal courts to control proceedings, the court determines that an extension, not a stay, is the appropriate relief here. Such an extension is in this case a reasonable response to the problems and needs. But the extension is only on the ATF bringing themselves into compliance. So the order of the court also reads, for the foregoing reason, the court denies defendant's motion to stay judgment pending appeal. The court grants defendants an additional 6 months to comply with the affirmative obligations, which shall be completed by February 22nd, 2025. If you are entitled to get an FRT back, they owe it back to you by February 22nd, 2025. But for some of you, they may actually owe it to you even earlier because the court also ordered this extension does not apply to the individual plaintiffs or members of the organizational plaintiffs who specifically requested the return of their FRT devices and provide sufficient documentation to the ATF. ATF shall return those as soon as is practicable following the specific request. So all of you who actually surrendered FRTs in operable condition, you are entitled to them back by February 22nd of 2025. For those of you who are named plaintiffs, which is very few of you, but those of you who are members of organizations that were involved in this, if you made a specific request, a demand to have it back, they're entitled to return it back to you as soon as humanly possible. The case, once again, is National Association for Gun Rights v. Garland. We're going to link up the order of the court down below so that you can geek out on it for yourself. Again, kudos to NAGR. Link to show them love down below in the description box. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but all of that information is down there in the description box. If you got an idea for a video we should do around here, go ahead and click on that link. Let us know what your idea is. If you want to subscribe to our monthly newsletter, the ability to do so is all down there in the description box. And then finally, and most importantly, America lets everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.